Hi, I'm Theo from Apify, and today I have Apify's COO and Chief Debugging Officer Ondra Urban to talk with me about the legality of web scraping. Ondra, thanks for joining me.
Yeah, thanks for being here, Theo. This is a really punk place to start our podcast or making videos, but we'll do our best and let's see what happens.
Great. So maybe we can start by you telling us a little bit about your background, especially like the legal stuff and how you went from that to developing and stuff.
Developing and stuff. Yeah, I find it funny because I'm no longer developing, right? So it's more of the stuff now. But so I finished law school, and I wasn't really happy about the job itself. Law is very interesting. It's kind of fun to do it, but not until you do it every day. And I just did not find it, I don't know, maybe challenging enough, or maybe it was just too repetitive or something. Frankly, it's been so long that I don't really remember. But at some point, and I think I do remember that it was in France. I was there with my girlfriend. I just, one day felt like, hey, I don't want to do this anymore. I felt like I don't want to wake up when I'm 50 and see 25 years of my life just doing something that I did not enjoy for 8-10 hours a day, right? So I was looking for a way out, and always liked computers and, toying with electronics and things like that. I built my own computers back in the day. I was hacking BIOSes and tiny things. I never really knew how to code, how to program, but it was something that I enjoyed. So I was thinking, okay, so let's maybe join a startup or something, like a tech company. And it felt like a good idea until I started going on for interviews for project managers, and I would always get into the second round or third round, and then they would be like, hey, dude, you're really good, nice, but you don't have the skills. Like, you don't know how to code, you don't have the knowledge that we need. And after a few failed interviews like that, I was wondering, okay, so what could I do? And obviously I needed the skills, right? So I applied for college, started studying. I still wanted to be a project manager or something. I did not really have the idea to become a programmer back then. But to get into the school, I needed to learn a bit of programming, like very the basics. And I just got so hooked on that. I could not believe it. Like, I really started loving programming within a week or two. And I just really wanted to dig into this more, and I wanted to understand how this whole thing works. And I just immediately knew that I loved this way more than I could have ever loved law. So over time, I kind of, reduced my commitment to my legal job. I only worked part-time, and I spent the other part-time studying and learning programming. And then at some point, I just quit being a lawyer, and I became a programmer.
Nice. So, is there some sort of a segue for you in terms of like the stuff that you used to deal with about legal things and what you do now? Like, do you find any overlap in terms of approaches? And
I guess the thing that I always wanted to find in law, I found in programming. Because the original idea behind being a lawyer was, okay, so you will have those problems that need solving, right? And it's law, so it's going to be logical problems. There are some rules that apply to the system, and then you understand the rules and you apply them. And if you're the best at applying those rules, you will win, right? But it doesn't really work like that. Law is much more about following the precedent, or following what people more senior than you, people who are judges, people who have been in the job for 40 years, what they say, not necessarily what might be the best solution. And, I'm not trying to say that they were wrong. It's just not the way you do business when you're a lawyer. There's not a lot of space for creativity, because to be on the safe side, you have to agree with the important people that have decided some things a long, long time ago. And then after you become this very respectable and knowledgeable person, you can have your own opinions and then maybe publish them in books or articles. And then after some time, you might get the chance of, let's say, becoming an opinion leader, and then your ideas might be brought to the table. But for a young person, this is extremely hard to do. And so you're just expected to follow the law and follow the procedure and just work with what other people have created. And I'd never kind of enjoyed that. You know, for me, when I made a contract, a specific contract, I don't know, for, you know, selling a building or for transferring a company, when I made it for the first time, it was fun. When I made it for the second time, it was kind of the same. And I was like, okay, when you make 80 of those, it started to get a bit boring with me. But with programming, you're kind of always building new things. You know, it's a very similar thing in the sense that the system has a set of rules that you have to follow, but then you can create whatever you want with those rules. You know, there are no boundaries. And the system tells you very fast that you're breaking the rules and that you have to kind of adjust, but it does not prevent you from building things. You just create and create and create. And when you actually have something, you make a library out of it or a building block of something, a component, and you never have to build it again. So the boring part is not there anymore. You just...
Coding is more creative.
Exactly, yeah, you just keep building it. And it also, I don't know, there's this very, like, you know, in the past few years, people have been talking a lot about, like, dopamine. I don't know if you noticed. It's like, dopamine hits, how to boost your dopamine, how to, you know, well-being and stuff like that. But this is really like one of the interesting things about programming is that when you're trying to fix something or when you're building something and it's not working and suddenly it is, you get this big dopamine hit, or like you just feel really good about it at that specific moment, which is something that I never felt when I was writing contracts, but I felt very often when I was coding. So.
Right. And why web scraping in particular? Oh.
Well, this started 5 years ago when a year into my first job as a programmer, I was looking for something new. Not necessarily. Well, my project kind of ended and I wanted new challenges, right? I was a junior programmer, so I didn't want to like get stuck in whatever I was doing there. I wanted something new to build. And so I started looking at maybe, you know, what job I could find, and literally I think maybe the first or second company that I would find on Startup Jobs, which is a portal for, you know, jobs and startups, was Apify. I was like, maybe I've heard that somewhere before. Then I realized it was not Apify, but Apiary, which was another popular startup back in the day. But what I found was they're doing web scraping. And I was like, wow, cool. I thought that was illegal, you know, so how are they building a startup around it? So I sent my CV, and this is how I got to web scraping.
Right. Well, you mentioned that you thought web scraping was illegal, and maybe many people have this impression. Why do people have this impression? There seems to be this idea that it's something shady. Was there a certain incident that happened that created this bad reputation, or is there, what's the reason?
Frankly, I mean, I don't know. Like, I have never heard about a specific incident that could have caused this, but I suspect it's because you're taking someone's data, right? Someone's property. But in reality, you're not. You're just copying stuff on the internet. But this notion that has been ingrained in people for thousands of years is that when you have something, it's yours and nobody can touch it. I think it makes people feel that when you come to their website and just download all the data on their website, that you just stolen something from them. And it feels very natural to think about web scraping like this. But it's not how it works, because to steal something, you have to remove it from one place or from one person and kind of like make it your own, right? But if you're web scraping, you're just making copies of things. So unless you know the technical details, it might feel like it. And I think for a long time, web scraping was a very niche thing. It was not a part of something that regular businesses would do every day to do market analytics, maybe to build new products by integrating public web data into them. And therefore, it was only used by a handful of companies. And the majority of the companies or people in the world were, let's say, victims of web scraping. They felt like victims, right? Because there were some other companies who were trying to steal the data. And they were talking bad about web scraping. And this is how this whole idea about web scraping being bad started, because there was no one to actually explain that is a very normal thing. And obviously, like with any human activity, there are some boundaries to it. You know, you cannot web scrape anything you want, just like you cannot drive any speed you want in the city. It's just there are some rules. You can drive, you can web scrape, but there are some limits, and everybody has to respect those limits.
It seems like a good opportunity to maybe address some other misconceptions about web scraping. Like, do you want to do some myth busting? What are some of the myths and misconceptions about web scraping?
Yeah, I would say the most common myth is the one we already talked about, right? That web scraping is illegal. That's simply not true. Web scraping is legal, but there are some rules. Actually, maybe the funny thing is, maybe it's funny to me because I'm a lawyer, but there's no law or precedent that talks specifically about web scraping. Or maybe now there are a few precedents, but there's no law. Actually, there is one law now even. Damn.
Which law is that?
It's the Digital Single Market Directive. Right. It specifically talks about web scraping, or actually it calls it data mining. But it's probably the only law that talks about data mining like this. There are some rules about copying databases, but they don't really mention web scraping specifically. But this is actually a law that talks about web scraping. Yeah. Anyway, with web scraping and with how to approach it, there's like no book or specific law that you get open to read. Okay, this is how I can scrape from the internet. Web scraping is governed by basically all the rules about intellectual property. There are also, contracts, because there is no underlying method to how to deal with this. This is just like, okay, web scraping is dealing with data on the internet, so you can have a contract for it, right? The data could be copyrighted. It could be personal data. And all those different laws obviously apply when you try to web scrape this data. So you have to make sure that you know all those regulations and that you follow them.
Well, what are some of those limits? For example, what kind of things can you scrape? And how do you go about, let's say, sort of scraping things like personal data ethically, or if there's even a possibility?
Yeah, I guess ethical web scraping is a concept that is important, but it's very hard to explain because everybody has a different notion of ethics, right? What I might find ethical, someone else might not find ethical. But for web scraping companies or for web scrapers in general, I think it's super important to try not to piss off other people. Yeah. And it's done by not only following the law, but by being a good citizen of the internet, right? Which means there's no law that tells me that I cannot overload a website. Obviously, somebody could come to me and say, "Oh, you caused me some damage," and so on. But no law prohibits it. But I don't even want to get to this point, right? I don't want to cause harm to the website I'm scraping. I want to be a good citizen of the internet. I want to scrape the data, but I also want to respect the website while doing so. And so in terms of personal data, it's very specific because obviously the general idea, especially now with GDPR, CCPA, CPRA, and all the other regulations, the general notion is that you should not touch personal data at all, right? But let's say there are exceptions. Like, for example, we're working with this company. It's called Thorn. It's actually a foundation, nonprofit, and they're helping find children that are being trafficked for sex, usually, like young girls. And the way that they do it is they collect vast amounts of videos and images from the internet, especially from porn sites and escort sites. And then they match those images and videos to the images and videos of missing kids. And through this process, they've been able to find more than 17,000 children in the US alone. So it's a very important project. I think it is very ethical, even though it scrapes personal data. What Apify does in this project is we are the providers of the data. It's us who go to those websites and scrape them every day, scrape the videos, scrape the images. And then Thorn builds a database of those videos and images and makes it searchable so that law enforcement in the US, then they can actually find the kids there. And even though GDPR, for example, would say, you know, those are pictures of people, personal data, you cannot simply scrape that. There are exemptions to this rule. So do you find it weird how it sounds in your? It's like having an echo of your. It's
not bad.
No. It's for me. It's like hearing your thoughts a bit later than they come.
That happens to me all the time, anyway.
Okay, fair enough. Yeah. Okay. So yeah, it's a public interest exemption. Basically, what we're doing is in public interest, right? So it's not only ethical to scrape this data because it helps save kids, but it's also legal thanks to this exemption in the law.
Cool. That's probably the most impressive case I've heard of. Are there any other examples of legal, ethical web scraping that come to mind?
Legal and ethical web scraping. It's like there are a lot of examples of legal web scraping, definitely. Then ethical, what's the bar for it, right? Does it have to be like for good? Or does it have to just be okay? I don't know.
That's a good question. I mean, there's one way to look at it is that it's for an ethical purpose. Another way that it's done in an ethical way. But I guess those are kind of two different issues.
Yeah. Whenever we're scraping something, we're trying to do it ethically, which means we're not trying to overload the website. We try to do it in the best way possible, you know, to consume as little resources as possible on their end. We try to use ethical proxies, which means proxies that are sourced ethically from people who actually know that their computers are being used as proxies. This is
so I mean, you have to have their permission.
Exactly, yeah. Because with residential proxies, there are basically two ways how you can do this. You can have an agreement with someone because they install an app or they just become willingly part of the system, and then you can route traffic through their computers, through their mobile phones, through their laptops, and they either get some benefit from it, like direct money, or they maybe have an application on their phone without ads, and for that they trade a little bit of their bandwidth, and this is all consensual and they know about it. But there are also levels of how consensual this could be, right? So for example, they could just click accept terms, and then somewhere in the clause 1375 there could be information about this. So technically they accepted the terms, but they had no idea that their phone was being used as a residential proxy. So let's say there are providers who can provide you with certificates or some assurances that the nodes, the proxies they're using, have been collected ethically, and that all the end users, all the node owners, they know what's happening and they are perfectly aware of it, and they're getting some benefit out of it. Or somebody could just get a botnet of webcams all around the world, you know, like hack into typically IoT devices, you know, fridges or whatever, and then use those as the proxies. And obviously that's a highly unethical way of acquiring those. Yeah. And then there's some, you know, spectrum in between. So it's not only important to scrape ethically, but also to make sure that the infrastructure you're using has been acquired ethically to do that.
All right. What would you say the landscape at the moment when it comes to the legality of web scraping? Is anything changing? Are there any particular cases that are important going on? And I'm especially interested in developments with AI and web scraping, because I think I've heard of some issues going on about questioning whether this is actually copyrighted data and so on. So maybe you could tell us a little bit more about that, how things are developing.
Cool. Yeah, so we've been looking into this as well because it's a really interesting topic. And I'll start with the AI stuff, and then maybe I'll move on to the other cases which are not as interesting. But as you mentioned, yeah, there are two very interesting aspects to the whole copyright and scraping and using wherever you could have gotten this data in building your AI models. And that's like, one problem exists on the input and one problem exists on the output, right? So let's start with the output. There is a question which is answered, hopefully now, whether the product of the AI. So whatever the AI created, whether it is an image, whether it's text, whether it's music or whatever, if this could be copyrighted. And the clear answer seems to be no, because it was not made by a human. And the rules all around the world that deal with intellectual property and authorship clearly say that, for something to have copyright protection, it needs to be made by a human in all various forms and factors, but this is the way. So this seems to be settled. Obviously, it's lawyers, so 10% will always disagree, but this seems to be the case that kind of the majority agrees that this is how it's going to play out. Whatever was created by AI cannot be copyrighted. The interesting part is how to deal with the fact that pretty much any AI in the world, especially the generative AI of today, so like Midjourney, ChatGPT, and all those, that they are built mostly or only thanks to vast amounts of copyrighted data that those systems ingested, and now they make predictions or generate text based on those source data, and nobody knows actually. It's a question that's gonna take some time to answer, and there are many different opinions about how this should go. Because you could very easily make the argument that, look, we built the system and we fed it billions of data points, right? And your personal piece that you published somewhere on LinkedIn or wherever is just one of the billions of data points. It's absolutely insignificant for this model, right? So it would fall under fair use, especially in the US and under some other exemptions in the EU. That because it's such a small part, it's like using one sentence from a movie or something. You're not infringing copyright when you're quoting Pulp Fiction. It's just, how copyright works. You have a certain amount, or you could use a small amount of the protected work and work with it without infringing copyright. And since this is such a small part of the model, then it should be okay. But then there's the argument of the other side, the copyright owners, and they say, but look, for example, this model of yours, it was trained on our huge database of photos, and now it generates photos that are very, very similar to the photos that the photographers that work for us have created, and we own the copyright to the whole database. So obviously to kind of like every single piece in it, but then to the whole thing as well. And you use this as your training data, and that's not 1/billionth of the thing, but it might be the whole data set, right? So now you're making money on something that we created, or our photographers or designers or anybody created, and we want a piece of it. And it sounds completely fair to me. Like, taking this a huge amount of data, feeding it into some model, the original creators should be getting something, right? So there's both arguments are kind of sound, like, hey, we're using just a small piece of whatever, so it's fair use. And then, oh my God, everything that the model can do is based off what we created, so we should have some fair share of the proceeds from running the model. Some people compare it to a human learning. So this is, again, an argument for not caring about this is, look, if you're a person and then you read books and then you study at university and you read more books and you watch videos and movies, and then you become a lawyer and you start writing contracts, you're writing those contracts based on the combined knowledge of everything you learned throughout your life, right? But you don't have to pay royalties from your contracts to all the people that wrote all the books that you read as a person. So that's, again, the AI creators are trying to make this argument. And I think it's going to take a long, long time before anybody solves this. And it might even be solved differently in different parts of the world, which is going to be the really interesting part, how they're going to deal with it.
It sounds like a really big issue to tackle. I mean, to me, it's like I become a musician by listening to lots of different bands, and then obviously I get influenced by what I've heard, and then I create something on my own that is based on that but isn't quite like that. I don't know how you could really
yeah
argue that that's belongs to someone or is copyrighted. It's hard.
Yeah, I think really where this shines is when somebody asks an AI to create a piece of art in the style of someone, because then obviously the AI specifically selects only the pieces of this person as the originals or as something that it should work with, and then kind of reimagines them. But obviously that kind of makes it a reproduction of the original pieces, right?
Huh.
Whereas if you just ask it to create any sort of thing, then it combines all the inputs and probably there is no copyright there. But as I said, no one knows now.
So you mentioned that you were going to talk about some other cases apart from AI. Is there anything going on that we should know about?
Yeah, like the AI debate is more about copyright than web scraping. Obviously, it's super important because to get this data, you have to scrape it or you could buy it somewhere. But in reality, all the, saying all is not a lawyerish of me, but I'd say most of the models I know about have been trained on data that's been scraped from the internet. So ChatGPT was trained like that, Llama was trained like that. I believe it's just how those models were trained. And if you look at Midjourney, I think it was also trained on data scraped from the internet. So it makes sense, but it's not, or it makes sense to talk about this in the sense of web scraping, but it's not really like web scraping case law. It's more about the specifics of copyright. But obviously the most important case law in web scraping in the past few years has been the HiQ versus LinkedIn case. Not necessarily that there would not be any other interesting cases, but this is one of the very few that actually made it through trial in some ways, because usually those cases are settled and then you don't really know what the legal status of this particular thing is, because if the company settle and the court never decides on the topic, then there's no rule, there's nothing to work with. But HiQ was specific in the way that the court decided, and they decided multiple times. It even got to the Supreme Court, which then sent it back to the lower courts. And I'd say the most important outcome of this case is that scraping publicly available data is not criminally punishable in the US, which sounds like something from, a long time, that somebody could criminalize you for or put you in jail for scraping data that's publicly available on the internet. But companies that were trying to defend themselves from scraping were actually making this argument that web scraping is hacking, and in the US there's a law called CFAA, Computer Fraud and Abuse Act, and it says that you can't be hacking. It's quite simple as that. And they were trying to imply.
Well, maybe just could you explain that case in a bit more detail? Like, what was the case against web scraping, and what was the outcome of the case?
The most important outcome of that case is that web scraping is not criminally punishable in the US. And I'm not going to go into the details, but basically there was an old law, or there actually still is an old law called CFAA that says that you cannot be hacking into computers. And some companies that were defending themselves against web scraping were using this law as a way to claim that people trying to download their data were actually hacking them. And the HiQ case is super important because it was the first time when somebody said, but look, it's publicly available data on the internet. You're not hacking anywhere to get it. It's just there. And then the companies were saying, yeah, but we deauthorized this specific person from accessing this data, so technically they're kind of hacking it. And the judge still said, no, when it's on the internet, publicly available for everybody, it cannot be hacking. And it's something that makes total sense, but for a long, long time it was not clear. So many of the big companies that were defending themselves against web scraping, they were using this as a way to put pressure on the web scraping companies, right? So unfortunately, this was the only big outcome for web scrapers out of this case, because the rest of the case was settled, and therefore none of the other questions that were posed in that case were actually answered, apart from the fact that kind of everybody expected that contracts should be honored. Because after some time, this case was going on. LinkedIn, well, the whole genesis of this case was quite complex. It was the first level decision, then the second level decision, then Supreme Court, then back to the first levels, and then out of those, we have the idea that web scraping is not criminally punishable. But then the actual case got decided on some points. And one of those points was, hey, those companies actually had a contract between them. So HiQ should not have scraped LinkedIn at all because they had a contract going on. And this is completely fair. I guess nobody was expecting that web scrapers would somehow be able to escape valid contracts that were signed between two parties. But I was still a bit hopeful that maybe the court could talk a bit more about what is a valid contract concluded in web scraping, and when you're scraping a website, what types of contracts are valid in terms of click wrap, browse wrap, and I'm going to talk about it in a minute, what those are. But the court did not really go there, so the case kind of died out, and in the end, LinkedIn and HiQ settled. And by the way, I think HiQ is now out of business because obviously their whole business was building analytics on top of LinkedIn data, and if they don't have access to the data, then the business is gone, right? But regarding the terms of use, so because I guess you would have asked that question.
Yeah, I was going to ask you that.
Yeah, so I'm just going to go right through it. One of the things that any person that's scraping the web should be careful about are terms of use of the website, right? But not necessarily what's in them, because most of them have a clause that says you cannot scrape this website. It's like completely ubiquitous, it's everywhere. So, but what they need to look at is the enforceability of those contracts. And for a very long time, there's been a notion that, contract or an agreement is, an agreement made between two parties, right? So they have to agree on something. And once they agree, both of them, and they accept the terms, then the contract becomes binding and they have to abide by what's in the contract. But with terms of use that are usually just buried somewhere in the footer of the website, nobody reads them, nobody shows the terms to you, it kind of breaks the whole idea of an agreement, right? Because they show you, they don't even show you the terms, they're just there, you never accept them, and then at some point later they come to you and it's like, oh, you breached our terms. The thing is, in most likely you did not. Obviously, there are some cases where this would be possible, but in most cases, you cannot be bound by a contract that you did not agree to. What this kind of brings me to the other topic, which is signing up to a website, right? And when you sign up to a website, you usually agree to the terms. And that's typically the point where suddenly this contract that you never read becomes binding and could be enforceable. And suddenly what you could have scraped, now you cannot scrape, simply because of the fact that you signed up for some service with the website.
Here we're talking about, so for example, when you're on a website and you just see a box that you have to tick to say, I've read the terms and conditions, that means it's now binding. Okay.
Yes. Some websites, but it's like extreme minority, they would have you accept the terms even without signing up by clicking some button somewhere or ticking a box that says, okay, I accept the terms. Frankly, I think there's like 1 in a million like this. It's either those that have the terms buried somewhere, completely invisible, or those that have you agree to the terms when you're signing up. And this is where the terms that are quite popular on the internet, browse wrap, click wrap, come from. Because browse wrap, or the terms that are called browse wrap, are the ones that basically you can just find by browsing, but you're not clicking anything. And then click wrap are the terms where you actually have to click something to, let's say, tell the website that you are agreeing to the terms, even though you might not have read it. And then obviously there are many different ways how to approach this, but those are like the two very generic terms that are used. And typically browse rep terms are not enforceable, which means, yeah, they are there. But if anybody would go to court and say, hey, they breached my terms, the court would most likely say, yeah, but those terms are not enforceable because the other party never agreed to those terms. Whereas with the click rep terms, the court could say, oh, but yeah, this person actually clicked here and said, I agree to the terms, so now they're enforceable. And this is the whole idea why scraping publicly available data is okay, but scraping private data or data that's behind the login might not be okay. And that's because the publicly available data are usually protected by browser agreements, which are not enforceable. So you can scrape the publicly available data. Whereas once you have to log in to get somewhere, you have agreed to the terms. And then by scraping the data behind the login, you might be breaching the terms. If the terms actually include some clauses that say that you should not be scraping, you should not have automated access and things like that.
Could you say a bit more about this scraping, things behind the login? Like what kind of situations are we talking about here?
Yeah, I'd say, let's say more all the modern social networks and lots of websites now generally, they will give you much more data when you're actually logged in, right? So on LinkedIn, for example, you might be able to open someone's profile, but it's going to be very limited in what it shows you. But if you log in with your own account and look at the same profile, it's probably going to show you much more data. So in terms of getting this data, it is way more convenient for the person who wants to get this data is to use some account, either their own or some fake account or some account they bought on the internet to access this data. But this is really thin ice because I'm pretty sure LinkedIn has in their own terms information about you not being allowed to scrape. So by using this account, you must have gotten the account somehow, right? So it's implied that you agree to the terms. Even if you cannot simply get rid of this liability or responsibility by buying the account from someone else. You kind of like, but he's the guy who clicked the accept. No, you're buying the account. It kind of it's implied that you accepted the terms, and because of that, LinkedIn can come and say, oh, you're scraping behind login. You should not be using this data. Please stop. Whereas, at least how the situation looks now, and it could change, but I feel it's getting better over time, so it's getting easier legally to scrape, not harder, luckily. So if you're only touching the data that's available without an account, you should be fine.
So let's say a developer is thinking of doing some web scraping and maybe has some doubts about, am I going to get into trouble here or there? What are there any steps you would, suggest that they follow that would, keep things quite safe? Like what advice would you give to a developer who wants to do web scraping but is a little nervous about the legal situation?
I'm wondering how much I can say as a CEO of a company.
Whatever you can get away with legally, I guess.
Yeah, whatever I can, right? No, I think everybody should understand this topic who wants to do web scraping. They don't have to understand it on a deep level, but they should understand the few basic topics that are covered by law when they're scraping, and they should know what could happen. And then obviously, when they have a specific project in mind, they should understand what this project requires, and then maybe talk to a lawyer to get an honest opinion. But thanks to the fact that we have fair use, for example, in copyright, we can say that scraping a few pages is not in breach of anything. And therefore, developers can start playing with web scraping without any sort of trouble. Then also, a very, very big use case of web scraping is scraping e-commerce websites, right? And those are typically not protected because you cannot copyright data. So if you just scrape product names, prices, and colors, this cannot be copyrighted, right? So you're pretty safe doing that. But then there are also rules about limited extractions from databases in the EU, and you have to be careful about that. So I would say I would not be afraid of scraping as a developer unless I want to turn it into a business. You know, as long as it is a hobby project, it's super unlikely that anybody would ever come claiming some sort of, breach of contract, breach of terms, breach of whatever. But once I want to turn the data into something that makes me money, I'd say it's very prudent to talk to a specialist and to kind of figure out, is the data I'm scraping copyrighted? Because for me, it's obvious, but for a person who's not a lawyer, it's not obvious. So just to have an idea about what is the field that I'm playing at is a good idea. And it doesn't have to be super expensive. Obviously, lawyers are expensive, but just this general analysis could be quite easy to get from, and this is important, from your local lawyer. Because obviously we're in the Czech Republic, the law looks like something here, then there's the US law, the EU law, and it's very important to know which law applies to you specifically as a dev who's trying to do web scraping.
But then does the law apply to where you are or where you're scraping the data?
It's another question that I have no specific answer to. It's an interesting thing about lawyers, they can get away with not giving you an answer. It's like, imagine a doctor, and I was like, is this the heart or is it the liver? Lawyers, they can do that. So it is extremely specific to the project. So let's say you're a German person scraping an American website through servers that are in France, and you're doing it for a company that's based in London, and then there's literally no answer to this question. Someone would have to go through, it's called conflict of laws. The whole legal theory behind it is called conflict of laws. And someone would have to go through the regulations for conflict of laws in all of those countries and see how they work together, and if there are some rules that they technically could use to figure this out. Usually the countries are trying to keep jurisdiction over many things. So how I assume this would play out is everybody would want to have jurisdiction, and then courts would have to decide who actually has jurisdiction. And this is very common in conflict of laws, that even the lawyers can't figure it out, so it has to go to court. And only the court then decides who has jurisdiction, and only then, when this is decided, the actual case can be tried. So this is not an easy question to answer.
I guess legal questions never are easy.
It depends how you feel. Like, if you feel like you can get away with not answering a question as easy, then yeah, they're very, very easy.
Right, well, that seems like a good place to wrap up. So thanks for talking with me today. And well, before we stop, we should mention that Ondra has a very comprehensive blog post about the legality of web scraping, and we'll put a link in the description so you can check it out. Thanks a lot.
Thank you, Theo. It's been amazing.